Hey, good evening. I'm standing outside the beautiful historic Harris County 1910 courthouse, and there's a couple reasons why I'm down here. One, this is where my legal career started. I was very fortunate when I was a law student. I got to work right in that building on the floor right above where I'm standing. Pretty honorable Elizabeth Ray. And one of my jobs was as a young clerk for the Harris County Civil District Courts to brief the judge about the legal issues that were coming up in the hearings every Monday and Friday. There were motion hearings, not trial matters. So one of the things that I wanted to touch base about was the Equitable Bill of Review and what exactly that is. A lot of confusion about the Bill of Review. It is not, as many people understand, an appellate remedy. It's actually a trial court. It's actually a trial court remedy. It's a remedy that a party who has had a default judgment rendered against them can bring to right a wrong that is based on a deprivation of due process. That's the easiest way I can explain it, and that in itself is a mouthful and a mindful, because it is a very complicated and difficult subject. A bill of review can be triggered any number of ways. The most common and frequent one is your standard default judgment. You've got a defendant to a lawsuit who has not answered. There is a presumption that somehow the service is valid, or somehow the plaintiff, the claimant, the complainant in that lawsuit has made representations and submitted some evidence to the court showing valid service, and a default judgment is rendered. In other words, there's no answer, a no answer default judgment. Now, generally you have 30 days to set aside a default judgment, and there's some conditions. And there's a big famous case out there called Craddock, and the Craddock factors, if they're met, you can set aside a default judgment within 30 days. I'll just touch on those briefly. There's one, got to be a deprivation of due process. Two, you got to be willing to pay the other side's attorney's fees for the setting aside for the hearing that they had to expend resources on to get the default judgment. And you've got to be able to establish that there was a lack of due process that rendered the default judgment. Now, where the Bill of Review can differ from this is that the Bill of Review has an additional element that the default judgment has to be rendered without the fault of that party requesting that relief or that party's attorney. Now, what makes that interesting and difficult, that there's exceptions to that rule, and those exceptions are all based upon situations where there's been an actual deprivation of due process. The Bill of Review procedure has this exception because that's constitutionally required by both state and, more importantly, federal notions of due process of litigation, of lawsuits.